Welcome to EUPrivacyForAll, Session 4 on GDPR, Profiling and Article 20. We already targeted GPIA's consent, further use of data. Today, let's focus on profiling. The key recital in GDPR related to profiling and automated decisions making is recital 58. In the essence, it provides that there is a right not to be subject to a decision that would be based solely on automated processing, if the decisions taken produce either legal effects or similarly significantly affect the data subject. It also provides that there should be a possibility to get human intervention. Framing automated decision-making includes profiling. Concretely, it targets information that would be deduced from a personal data processing on the performance at work, economic situation, health, personal preferences or interests, reliability or behavior, location or movements. During negotiations, European Parliament and EU Council picked up a different wording. European Parliament, with profiling, was granting a right to object profiling, and data subjects should have been informed in a highly visible manner. EU Council, regarding automated individual decision-making, provided a right not to be subject to a decision based solely on automated processing, including profiling, when it produces legal effects or significantly affect a data subject. The key provision finally retained in Article 20 is entitled Automated Individual Decision-Making, including Profiling. It bridges between the two wordings. The final provision is really close to the Council version. What is recognized is a right not to be subject to a decision based solely on automated processing when it produces legal effects or significantly affects a data subject. This is also really close to the Directive current provision. In 3 cases, such a provision does not apply. That is to say, when there is a contract, when a specific law applies, and when there is a data subject's explicit consent. The right to obtain human intervention on the part of the controller is also recognized. And finally, GDPR lays down the fact that there should not be automated individual decision-making when it comes to special categories of data, that is to say sensitive data or data related to criminal offenses. There are 3 other interesting provisions in the GDPR, Article 14.1AH, 14A2H, 15.1H, on respectively the information to be provided where the data are collected from the data subject, where the data have not been obtained from the data subject, and on the right of access. Those 3 provisions require information on the existence of automated decision-making, including profiling, and that is to say a meaningful information about the logic involved, the significance of such a processing, and the envisaged consequences of such processing. Currently, the Directive provides in Article 15 almost the same provisions as in Article 20 in GDPR. There is a right to every person not to be subject to a decision which produces legal effects concerning him or significantly affecting him, when it is based solely on automated processing. Additionally, Article 15 provides that there is a possibility to be subject to a decision of this kind in the frame of a contract or in the frame of a law that would also lay down measures to safeguard the data subject's legitimate interests. Moreover, the directive has a recital 41 that reminds us with the principle involved about informing transparently data subject. Data subjects should know the logic involved in the automatic processing of data concerning him. However, this should not affect trade secrets or intellectual property, and in particular the copyright protecting the software. This was mentioned in the directive explicitly. Article 12 of the directive currently provides that there is a right to obtain from the controller, without constraint, at reasonable intervals, and without excessive delay or expense, a knowledge of the logic involved. This is pretty the same provision as in GDPR. What should accountable data controllers get prepared for? First, not solely use automated means when it comes to make a decision producing legal effects or significantly affecting a data subject. That is to say, building a process to add human intervention and get data subjects' observations. It also includes providing systematic, meaningful information about the logic involved, the significance, and the envisaged consequences. Finally, it means providing a right of access. Recital 58 of GDPR mentions some additional restrictions in the way to process data when it comes to profiling. Suitable safeguards should be provided. Human intervention should also be put in place. Profiling should not concern a child, and other restrictions. Additionally, data inaccuracies should be corrected, and the risk of errors should be minimized. Basically, all those measures aim at one thing: preventing discriminatory effects against individuals. Finally, EDPB guidance seems to be needed.